welcome back to the channel. My name is Varun Kaushal and I'm a legal intern at LEXIS and Company. Today I'm going to discuss about alternate dispute resolution. In 1963, Martin Luther King Jr. used the phrase "justice too long delayed is justice denied" in one of his letter from Birmingham jail, which was smuggled out of prison. Quite unfortunately, this phrase can find its own relevance even in today's society and is commonly referred to as justice delayed, injustice denied. The low efficiency of the Indian courts and the vast magnitude of pending cases are a result of the plentiful population of 1.37 billion residing in the country. Most of the time, justice is served late and cold, taking up years and sometimes even decades. To eradicate the crisis in the Indian courts and the Indian judicial system, ADR, or the alternate dispute resolution, is a savior to all the victims yearning for justice. What is the origin of alternate dispute resolution? In the year 1899, an English legislation-based act was enacted for giving effect to the mechanism of ADR in India. This act was referred to as the Indian Arbitration Act 1899. Later, in the year 1908, when the Civil Procedure Code 1882 was amended, it gave powers to the courts to refer the conflicts to ADR mechanisms through Section 89. India also signed and adopted the Geneva Convention in the year 1937, which gave a way to the emergence of the Arbitration Act 1937 in the country. The Arbitration Act 1940 came into existence after Section 89, along with the second schedule of CPC, and the Indian Arbitration Act 1899 was replaced. In 1996, the Arbitration and Conciliation Act 1996 was enacted, which is a single piece of legislation that deals with the ADR. It emerged after the consolidation of three acts, namely the Arbitration Act 1940, the Arbitration Act 1937, and the Foreign Award Act 1961. This has made the work easier, as the Arbitration and the Conciliation Act 1996 is a consolidated form of various legislations and is effective. In the rural areas, especially in villages, small disputes among the villagers were sought for with the help of panchayats. What are the forms of ADR? Number 1. Arbitration. It is an informal trial that includes a neutral third party which decides the case after hearing both the parties involved in the dispute. A process of arbitration can start only if there has been a valid arbitration agreement in writing. The decision can be binding or not binding, depending upon the clause of the contract. If it is decided in the contract that the decision will have a binding effect, then the decision will be enforced by the court and will be regarded as final. Either of the parties can arrange for an arbitrator. In a situation of non-cooperation by the other party, one can also seek help from the Office of Chief Justice, who in turn appoints an arbitrator. An arbitrator should always be beyond the reasonable doubt of impartiality and should be qualified enough to be an arbitrator as per the arbitration agreement. Second one is mediation. The mediator cannot force the parties to agree, and so it's the duty of the mediator to make sure that the decision is mutually agreed upon. He also cannot decide the case. The process of mediation is voluntary, so the parties have free will to refuse to come to an agreement. It is non-binding in nature, which allows the parties to go for litigation if not satisfied. Mediation can be between two or more parties. It can involve communities, organizations, states, individuals, and others. Negotiation. Here the parties come to a mutual agreement without a third party intervention. In many cases, parties are represented by their respective attorneys who fight for them. Parties bargain and compromise to come to a mutually accepted ground. This kind of ADR mechanism is often used by non-profit organizations, business dealings, marriage, divorce, etc. Number 4, conciliation. Conciliation is another form of ADR. Usually one conciliator deals with the proceeding. However, there can be more than one conciliator as well. In cases where there are more than one conciliator, all the conciliators must act jointly. Either of the parties have the right to opt out from conciliation if he or she wants to. If the conciliator is of the view that there exist elements of settlement, he then stands the drawn up terms and conditions to both the parties for their acceptance and approval. If both the parties agree and sign the settlement document, it shall be considered as binding and final on both the parties. Number 5, Lok Adalat. The Indian concept of Lok Adalat has come from National Legal Services Authority Act 1967. It can settle matters related to disputes which were at the pre-litigation stage or pending in the court of law. In Lok Adalat, parties can directly communicate with the judge, unlike the long ongoing court cases. It does not need any procedural requirement as mentioned by CPC or Evidence Act, thereby making it a much faster process. If a matter which was pending in the court of law was later settled by Lok Adalat, then the court fee is refunded. Here, the members try to assist the parties to come to a common ground which can lead them into a settlement. What are the advantages of ADR? ADI provides for a speedy justice to the parties. It is effective and efficient and processed in a smooth manner. It is cost effective. Lok Adalats are free of cost, and other forms of ADI require lesser amount of money compared to the general court proceedings. Satisfaction of the parties, as per the parties are involved in the case, it helps them to have their own ways of settlement, resulting in mutual understandings. The result is qualitative and productive. Now I'll tell you one of the case fact, which is Vinod Bhaiyalal Jain and others v. Vadwani Parmeshwari Cold Storage Private Limited. Appellants in the case was Vinod Bhaiyalal Jain and others, and respondents in the case were Vadwani Parmeshwari Cold Storage Private Limited. The appellant had a business related to agricultural products in the year 2004. The appellants had availed the services of the respondent, who was the owner of a cold storage. So 50 kgs of singara, a fruit, was kept in the cold storage, which was managed by the respondent. The appellants were of the view that his products were damaged due to failure of the respondent to keep them in the proper manner. When the appellant claimed compensation for the damage, it was denied by the respondent, and subsequently a dispute arose. The father of the appellant in due course got to know that the arbitrator in this case is the same person we had already fought as a counsel for the respondent in a previous case. Despite such objections from the side of the appellants, the matter proceeded in arbitration, if thereby directed the appellants to pay rupees 43,000. The matter went up to the district court in Nagpur, which said that the objections raised by the appellants were justified and decided that the award of the arbitration would be set aside. The High Court reversed the order of the district court by stating that even if the arbitrator had appeared as a counsel of the respondent before, it is not a ground to hold him as partial. So the decision of the district court was quashed, and the award of the arbitration was restored. Finally, when the matter was taken up to the apex court, it quashed the decision of the High Court and restored the decision of the district court. In conclusion, I'd like to say that India has had a long history of delayed, pending and never-ending judgments. The country has seen numerous stories of futile proceedings, court appearances and hearings. Although these complications still pose a threat to the citizens of the country, we can see that the society and the fraternity is changing, and so is its system of functioning. Delayed justice is no more an acceptable issue. People want results, and they want them fast. Alternate dispute resolution could provide prove riposte to the crisis. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe our channel LEXCLIQ.